Hi there, this is attorney Candice Carr with Ouellette Carr and Spectrum Title Services. I'm a real estate attorney here in the South Florida area, and this is a quick video on power of attorney and its uses with respect to real estate transactions. So let's first talk about some possible uses for a power of attorney. The first thing is the listing agreements and contracts. Those are some of the initial documents when we're talking about real estate transactions that can be signed under a power of attorney by either the buying side or the selling side. Seller's documents. These are probably the most common documents that we see signed using a power of attorney. Everything from a warranty deed to affidavits to a closing statement, a HUD document. Buyer's documents, again, affidavits and a closing statement. Loan documents can be signed under a power of attorney by whoever the borrower has appointed as their attorney in fact, and we'll talk about some requirements when we're dealing with loan documents a little further on in the video. Also, construction contracts, permits. A lot of times we see this when somebody has purchased a property but they are often traveling out of the country and they have somebody that's going to manage the property for them. They'll often do a management agreement or power of attorney for that property manager, so that person can deal with the county, city, have work done on the property, that type of thing. That attorney in fact, can do that in their absence. And when I say attorney in fact, that's the person who has been appointed under the power of attorney to act on behalf of what we call the principal. So some of the requirements that we look for when we're seeing a power of attorney being used in a real estate transaction. First thing is that we like to see a specific power of attorney. So a document that is done for the specific purpose of the real estate transaction that it's being used for. And that's opposed to a general power of attorney, which doesn't list any specific reason for the power of attorney. The parties obviously need to be listed. Who's the principal or who is the person appointing an attorney in fact to act on behalf of them, and then who is that attorney in fact that's being appointed. A legal description. This is something that's very important. We like to see that the specific power of attorney is for a particular property. So we know that this person is authorized to act on behalf of the principal when dealing with a very particular property. A power to sell and convey real property. If seller's documents are being signed under power of attorney, then this language must be in there. The attorney in fact must have the power to sell and convey real property and to sign especially a warranty deed. A lot of times when I am representing sellers and I'm going to be signing documents on their behalf under a power of attorney, I at least have them sign the warranty deed prior to them leaving the country or traveling or whatever the case may be. I like to have the warranty deed signed by the actual sellers, and then there are some of the other documents that can be signed under a power of attorney. Now, warranty deed can be signed under power of attorney, but that's not my preference, and a lot of times seller's documents can be signed prior to closing anyway. 2 witnesses. The power of attorney in Florida must be executed under the same laws that a warranty deed is executed. So that means 2 witnesses and a notary. And one of the witness obviously should not be the person that's being appointed as the attorney in fact. They should not be a witness, nor should they be a notary on the power of attorney form. Lender approval. Now this is where I talked about if loan documents are going to be signed using a power of attorney, we as a title company require that the lender approve that power of attorney. They often have their own form that they want to see. The form that we usually use, I've never had a problem with a lender accepting it. The power of attorney forms that we use are very specific, but sometimes the lenders have their own form that they want, and there are certain things that they want to see. So this is something that needs to be dealt with ahead of time. If a borrower is going to have loan documents signed under a power of attorney, then we need to get the lender's approval, and they'll often draft the loan documents with the power of attorney language on the signature line. And this is very important. The original power of attorney must be recorded. I've a lot of times had people who have an original document, they don't want to give it up, they want to hold on to it, but you have to. I mean, we have to have an original power of attorney, and that original must be recorded with the seller's document if it's being used under the seller's side, or with respect to the mortgage if the loan documents are being signed using a power of attorney. So that's one thing to note, is that we cannot take a copy. We must have an original. Okay, so those are some of the uses of a power of attorney in Florida for real estate closings and some of the requirements. Please visit realpropertyu.com. We have tons of free educational videos for buyers, for sellers, and realtors. There's a lot of information out there that we give to make real estate closings an easier process for everyone. So please check it out, and don't hesitate to give me a call or send me an email if you have any questions or if there's anything I can help you with. Thanks for watching.